continue with Intrepidus Law, and we'll come to you when it's time to come back for opening statements. Please continue.
Thank you. Thank you for the opportunity to provide evidence today. Intrepidus Law has a practice focus on appealing NDIA decisions at the Administrative Appeals Tribunal. Our clients are NDIS participants seeking external review of NDIA decisions after receiving an unacceptable internal review outcome. We also support people seeking access to the scheme and appealing decisions to deny access to the scheme. We do not support the bill as currently proposed. We cannot support a bill that fails to provide basic procedural fairness and natural justice protections to Australians with respect to government decision-making, powers which will have a significant effect on Australian lives. The deficiency in review rights is at the heart of our concerns with this bill because it will expose our most vulnerable citizens to decisions which may pose an unacceptable risk to their lives without the safety net of procedural fairness to review those government decisions fairly. It is a fundamental tenet of democracy and the rule of law that a citizen have procedural fairness to question a decision made by government that impacts them so intimately and to have the right to be heard or in particular provide further information and evidence about their disagreement with that government decision. It is also important that we are treated as innocent until proven guilty, and we hold significant concerns this bill provides powers to the agency to take away rights without proving the case it is alleging first. It is particularly concerning with respect to the debt-raising powers being proposed. Intrepidus Law is concerned that there are a number of new decisions included in the bill which lack review rights in circumstances which will significantly impact a person. It is essential these decisions are reviewable. We hold significant concerns about the bill and the impact it will have on women, in particular unpaid carers, who are mostly women, and who will be the ones forced to supplement deficient support funding with unpaid care work, forced to quit their employment and forgo financial independence to support their disabled loved ones because supports will be reduced with this bill. We are concerned about the impact on people with extreme functional impairment who will be funded 1:3 ratio support packages as a result of incorrect needs assessments, which will bring back the dark ages, we fear, of institutionalisation and group homes. The proposed needs assessment is still deeply problematic due to the lack of information provided about a key instrument which will determine a person's supports. It will form the foundation of determining a reasonable and necessary funding package. However, we still don't know the tools that will be used, how will they be performed, who will perform them, and can the participant choose, what rights a participant has while being assessed, if any. Will the details and experience of the person making the assessment be provided, the cost of the reports and what the reports will actually contain. This basic information should be provided for consultation before changes are introduced. It is fair to say there is no one assessment tool that can measure the impact of disability on all people fairly and accurately. Disability is a multifactorial condition and it affects people differently. It can fluctuate and depend on one's environment at any given time. A needs assessment using a single tool, which we know little about, to decide needs is unlikely to be fair or correct. It is likely, however, to lead to bad decisions. To support better decisions, procedural fairness, needs assessments should involve, as a minimum, consultation with the person's treating practitioners and their current support team and the participant themselves. This would not only support a better understanding of support needs, but reduce future costs for the scheme in reassessments being reconducted down the review path again and again and producing the same deficiencies because of the same tool being used. It is essential that a participant have the opportunity to present their own information about what their needs are and a decision maker is not constrained by a needs assessment report in making their decision. They must have the benefit of other information like statements of lived experience, allied health reports, medical evidence that a person with disability can provide. We are very concerned with this departure from the current review path. Currently, when someone seeks review of their funded supports, updated evidence and new information can be provided, statements and reports can better inform decision making. That procedural fairness appears to be eroded by decision makers and reviewers being constrained by this narrow lens of a needs assessment and any replacement of that needs assessment without the benefit of other information, or indeed being able to request different types of assessments which may better suit different types of disability. We consider the deficiencies with the needs assessment and lack of review rights for decisions will be the root cause of unacceptable risk of harm to participants if this bill is to pass. The risk could be mitigated by cementing basic procedural fairness and review principles into the bill as part of the decision-making process. Thank you.
Thank you very much.